Hello.
Hello.
Oh, I can hear you.
I'm also.
Hello, Sador. I'm here. Can you hear me?
Good afternoon, dear students, dear participants, and welcome to the last event of our teaching and learning legal English skills. And in the last event, in the last session, we invite our honorable guest, Laszlo Szabo, one more time. And let me send a notification to our students group one more time so they can just join, and probably they are on the way. I haven't sent the notification yet. And 1 minute. Also, I'm going to allow the screen share in the security settings.
Thank you.
Okay. I believe everything is okay. I've sent a notification to our students group just one more time. And so I believe we can start, right? And welcome our keynote speaker and our dear students. And today we are going to have the last event of teaching and learning legal English skills event. And as you're probably aware, we are going to have this event every year annually. And starting from the last year, we invited a couple of keynote speakers, and this year too, we invited new experts to our events, and our students have a very great chance to have some experience and practice in legal English. Especially we are going to focus on legal English because that's going to be the area which we are going to learn in the future. And today, in the last session, we invited Laszlo, and he's going to talk about in today's class, today's event. It's going to be civil procedures, and we are going to especially focus on the language of the civil procedures law. And I believe I can give the microphone to our keynote speaker, Laszlo. Laszlo, welcome.
Yes, I'm here. Can you hear me?
Yeah, surely.
Great. Just a moment. I'm looking for my face a little bit. Can you see my face also?
Yes.
Okay, I'm glad. I'm glad again to meet you here, and I'm also very glad that I can speak to you, to you university students in Tashkent, and I believe that I can help you, and I can offer some good idea how to be excellent in legal procedures. You know, I'm a legal translator, from translating from Hungarian into English and from English into Hungarian, company law, contract law, and also court documents. So I'm familiar with this subject, and I translated a lot of text in it. So I have experience and qualifications in this subject, and I'm trying to show the. And now, can you see a Word file?
Yes.
Okay, so today we are going to speak about civil procedure. In other words, how court works in English, and we will have this. Okay. First, let me introduce myself a little bit. I completed a law course at University of Yale, and also I passed test of legal English TOEFL at the advanced level. So these are my qualifications in addition to being a translator. I mentioned to you in my 2 previous lessons that to be successful in legal English, you have to know 10 things. First of all is Uzbek law, which you know very well. You have to know Uzbek, ordinary Uzbek languages, again, which are excellent. And then you have to know the linguistic environment of legal Uzbek terms, and then you know legal Uzbek language, and you are already excellent in these subjects. And also you know a lot of Uzbek legal terms and US and UK legal terms. You know them hundreds and thousands. And then we will check what the linguistic environment of US and UK legal terms are, so that you can write excellent sentences in legal English in lawsuits, in relation to lawsuits. So basically, we will cover some terms, legal terms, and then we will see some topics in US and UK law, and then we will see how UK and US lawyers speak about civil procedure. Here we have a brief introduction into the subject. We have a lot of English words: trial and court and lawsuit and held and judgment. So we will see how these work in practice. Okay, so first we check some Uzbek and English legal terms. You can see that this Uzbek legal terms goes to defendant in English, and sud is court in English, and devo is lawsuit, and all the others that you are much better than me. And finally, dalil, this is the first expression that I learned with the language. Okay, so we will see a story, and in the story we will learn a lot about legal English. Here we have a truck which delivers goods to this factory, and when it enters the factory, accidentally it crashes the fence, and crashes the fence, and there is a damage. And the driver and the factory tries to agree and try to settle the case, but they cannot. So there is a lawsuit. There is a lawsuit, and this is the story of the lawsuit. Please read it. This is in Uzbek language. So this is what happens, and then please read it for yourself. And finally, here we have this sentence. So you get the idea what happens, and we will see how this very good Uzbek text is expressed in in legal English. This is a brief overview of what we are going to talk about, what the conditions for trials are, and then how we will express purpose in civil procedure, how to submit claims, how to respond to claims, and what is fact-finding, and what parts are there. There are testimonies and evidences, and then when the facts of the case are found, then the court will pass its judgments, permit something, prohibit something, orders something, and then holds something. And then if the parties do not agree with the judgment, there can be appeals, and the appeal can be successful or unsuccessful. So this is the issue this is the subject that we are going to cover today. Okay, so let's see first that we have conditions for trials. We have here a bit of introduction, which you don't read it. For example, in personal terms, there are personal conditions. The defendant must be fit to plead or fit to stand trial. It means that he must be an adult and he must be a sound mind and things like that. So this is the way of expression. The defendant had established that he was unfit to plead. It means that he cannot be sued. So these are the personal conditions for a defendant, and there are also personal conditions for the plaintiff. A plaintiff can have standing to pursue action for wrong. For example, you can see it in the sentence: the second creditor has standing to pursue action for willful violation of the automatic stay under the act, or the person is found to have or found to lack standing. When the plaintiff who brought the suit is found to lack standing, the suit is dismissed. So these are the personal conditions to start a lawsuit. And then we have another condition for the court. For example, a family court cannot deal with a damage issue like this. So this means that the court should have jurisdiction, and this is expressed in the way that court have jurisdiction to, and we have the sentence, for example, the court have the jurisdiction to adjudge the case, which means that he can consider the case and he can pass a judgment in the case. So basically, these are the third condition to start a lawsuit. And also, a case must be something that comes into the jurisdiction of the case. This is much the same as this above, but you can see the case can come under, come within, fall beyond the jurisdiction of the court, which means that this fence issue, this fence damage issue comes within the jurisdiction of the court, which means that the court can consider and pass a judgment in the case. And there is also a fourth condition, the statute of limitations. It means that if the case is very old, for example, years old, for example, 5 years old, then the court will not start the case. And we have a person focus for this to express. For example, the entity is barred by statute of limitations from doing something. It means that, for example, the delivery company or the truck driver can be barred by a statute of limitations from lodging a claim, because it can be too old, for example, 5 years old. But if the case is just recent, not very old, then there can be a trial. Again, not just person can come under a statute of limitation, but also a case can come under the statute of limitation. For example, this lawsuit comes under the statute of limitations. It means that it cannot be considered that and no judgment can be passed in the case. So if all the conditions are met, the personal conditions and the jurisdiction condition and the statute of limitation condition, then there can be a lawsuit. And we have the factory here, and the factory wants to have damages, want to have compensation from the driver for the damage that the driver has caused, and then the factory sues the delivery company. And then when the factory sues the delivery company, this company can ask the court to give him damages or give him compensation for the loss. We say it in legal English to the person move for entry of condition, the person moved that the court award damages for the factory. So this is how to express our purpose in the civil procedure. Then we come to the part when the factory can submit the claim, and we will read it here. So this is a brief summary about from US and UK law. What do we know about submitting claims in legal actions? It says a civil action is brought by the claimant's attorney who drafts a complaint or a claim or a petition. It sets for the claimant's legal claim against the defendant, together with description of the jurisdictional basis for the legal actions and the legal relief sought by the claimant. Once the complaint is filed with the court, either the claimant or the court, depending on the jurisdiction, provides notice to the defendant of the complaint. This notice is called service of process with a summons. It directs the defendant to respond to the complaints of the claimant. Once the defendant has received the notice of the complaint and a copy of the filed complaint, a civil action is deemed to have been instituted. So this is the way a lawsuit starts. It starts by the attorney of the defendant. It sends to the court a document which is called a petition or a claim or a complaint. And in this petition, the attorney says we want compensation for the damage that is caused. And then comes the next stage of the legal procedure when the defendant responds to the claim that is submitted by the defense attorney of the defendant. So as discussed above, the documents are sent to the defendant. The defendant must respond to each of the claimant's allegations by submitting his or her answer, either by admitting or denying allegations, or pleading a lack of sufficient information to admit or deny the allegation in the complaint on the claimant's claim. So basically, if there is a petition, then the defendant must either admit or deny what is written in the petition. Then the defendant may also respond with a demurrer in which he claims that the cause of action alleged by the defendant are defective and no answer is necessary. When responding, the defendant may also assert any counterclaim or claims for equitable relief against the claimant. So in the answer, it's not only writing if you admit or deny the allegations, but also the defendant can say, okay, you claim this and I claim that. So basically they can lodge, they can make a counterclaim. And the defendant may also request that the claimant's complaint be dismissed by filing a motion for summary disposition. The defendant may also decide to dispute the validity of the complaint by filing a demurrer or a motion to dismiss the case, a motion to strike, or a motion to quash. A motion for a more definite statement may also be made to seek more specific information as to the claims made by the claimant. In cases where the defendant is duly served with the relevant court document and fails to file his or her answer to the complaint, the claimant may request that the court make a default judgment against the defendant, whereby the relief requested by the claimant is awarded and no trial is necessary. So basically, we will move on to the next stage when we have mentioned that the defendant may admit or deny the allegations in the petitions, and we have sentence patterns here. A person admit that subject verb. For example, we can say the defendant admitted that he or she took the laptop from the premises. So basically, admit that, and then comes the sentence what is admitted. And then if they can admit something, then they can also deny something. So basically, a person can deny that subject verb. The plaintiff may deny that the possession of the testator was wrongful or unlawful, or I can say that I deny any allegation that the plaintiff is the owner. So basically, here are the sentence patterns that we can use in expressing admission and denial in a lawsuit. And then comes fact-finding. Fact-finding is a process where the court finds out the facts of the case. It says, this is a brief introduction to US and UK law. Fact-finding is a process at trials for the discovery or determination of the facts of the case before the court. At the trial, fact-finding is a process by which the court or the jury reviews the proffered evidence to determine the facts. Evidence can be witness testimony, expert testimony, declarations, and submitted documents and photographs submitted through discovery. Discovery refers to an organized exchange of information between the parties before the trial. Common types of discovery include interrogatories, requests for production of documents, requests for admissions, and depositions. Interrogatories are written questions that one party asks the other party to the lawsuit. Then there is a response. The responses, which are in writing and under oath, must be honest, accurate, and complete. Demand for the production of documents occurs when one party requires the opposing party, and sometimes non-parties, to provide hard copy or electronic copies of documents. A request of admission is where one party asks another party to admit to an indisputable piece of evidence, such as a residential address or age. Admissions eliminate wasting time at the trial, establishing facts no one disagrees about. Finally, there are depositions. These are sessions where one party asks another party for questions. Then the responding party or non-party witness provides verbal responses under oath that are documented. On completion of this stage, of the process, an attorney may meet the judge informally and discuss the case together. At this stage, the process may end in an out-of-court settlement between the prospective parties. In many jurisdictions, the pre-trial settlement discussions is mandatory. If the case proceeds to trial and witnesses are required to give testimony in a case, they are called to appear before a court in a subpoena. When a witness is subpoenaed and asked to present certain documents in a court, the process uses subpoena duces tecum. So basically, this is the process whereby the facts of the case are established. So there is evidence, there is testimonies, and we have these two sentence patterns. Person testify, that subject verb. For example, in the above case that we have about the factory and the delivery company, we can say that the security guard testified that he saw the truck driver run into the fence and break it. So basically, these are the two most often used sentence patterns in testimony. And then we have the defense. When the truck driver can say, okay, I actually broke this fence and I caused damage, but I have defenses on the basis of this and that fact. And in this context, we have some very good sentence patterns. The person stated in defense that subject verb. For example, the defendant stated in his defense that he didn't go to work that day, or the defendant may not raise the defense that the claim was time-barred. So another sentence patterns we can use: a person raised defense that subject verb. Again, we have another very useful sentence pattern. It is defense to show that subject verb. It means that if a person can show that something happens, then it is a good defense, and then it's a cause for relief. And then again, there are certain facts that cannot be used in defense. For example, in the sentence, it is not a defense to claim that the trademarks are not liable for confusion, which means that this is not an acceptable defense. And this sentence shows that this is an acceptable defense that the defendant had mentioned. Okay, we have the evidencing. Evidencing is a very complex subject, and I'm going to provide a separate ebook for this. So I will not go into more detail about evidencing. Then, when the facts of the case are established, when the courts find what actually happened and nothing more and nothing less, just completely what happened, then the court will pass its judgment. Let's see what we have to know about court judgments. Court decisions usually set forth a range of administrative data, including the case caption with the names of the parties, the docket number of the case, citations, in which is the date and the location of the decision of the reporter, the date and the name of the judge. And then there is a substantive information which covers the procedural posture of the parties, that is, who won the case, and there is a description of the case between the parties, and then the decision of the court and the holding regarding the court's application of the law to the facts of the case and any relevant finding of fact. Then once the court announces its decision, the losing party may either comply with the judgment or may fail to comply with the judgment. A losing party's failure to comply with the judgment compels the prevailing party to obtain an order enforcing the terms of the judgment. So basically, this is the way court judgments are made. Okay, so court judgment can have a number of contents. For example, court judgments can permit things. Let's see some good examples for this. A court enters the order, court enters or issues or grants or puts in an order, approving, allowing, authorizing, enabling, or permitting a person to do something. So this is a very useful overview table in which we can see what verbs are used by UK and US lawyers when they permit something in court judgments. And then court judgments can prohibit things. For example, the court enters, issues, grants, or puts in an order, a judgment, or ruling, or restraining orders, or a verdict. Boring, enjoying, preventing, prohibiting, or restraining. These are the words, very important words used in prohibiting things. So prohibiting a person from doing something, from working. So they are very, very important and very, very useful verbs and overview tables to know. And then court judgments can also prescribe things. For example, the court enters judgment, enters order, or enters verdict, ordering, instructing, requiring, or compelling the defendant to do something. So this is also very useful, these words, ordering person to do something. And then court judgment not only permits and prohibits and orders things, but also they can put forward facts. For example, the judgment sets forth that the jury returned their verdict that they found a plaintiff and made the following estimate of the property. So basically, court judgments can also establish facts. Okay, so we have covered what court judgments can do. So court judgment can permit things, court judgments can prohibit things, court judgments can prescribe things, and then we come to the point when we speak about courts, when courts permit things, not court decisions. It says the very useful overview table is here. The court allows, permits, and authorizes a person to do something. Or we can say that the court consents to persons, verb, thing. So this is how a court permits things to be done. And then we can say that courts also prohibits. Courts can also prohibit things. For example, a person is restrained from working. The city is restrained from enforcing the legality of the occupancy until further order judge is issued. So basically, this is the very useful and very commonly used terms. Or person is ordered to cease and desist from violation of instrument. There is an order for the person to stop, basically to stop violating the instrument. So this is how persons are prohibited from doing something. And then we have here also the court focus, in which the court can enjoin or prohibit or prevent a person from doing something. This is also very useful and commonly used verbs and terms. Again, courts not only can permit and prohibit things, but they can also prescribe things. And then we have the court person focus, when person is compelled, is forced, is instructed, is ordered, very often used, is ordered, or is required by the court to do something. This is basically the sentence pattern here. Or the person gets an injunction, gets an order to do something, or obtain an injunction to do something, or receive an injunction to do something. For example, this sentence is a very good example for this. An individual who was arrested has been ordered by the court to undergo counseling in lieu of prosecution. So basically, person is ordered by the court to do something. Or we can say a person receives injunction to, for example, compels receive a court-ordered injunction to vacate the park or risk being in contempt. So this is the terms we have to use the idea of court prescribing. And then we also have the court focus. The court compels or forces or orders or requires the person to do something under the court decision. So, for example, the court compels the person to, if a court cannot compel an expert witness to testify. So basically, these are the verbs that we can use. And then finally, we have the court when it establishes facts. It says the court or a jury holds that subject verbs, or concludes that subject verbs, or establish or determine that subject verb, or the court finds person as adjective. For example, we can say the court found that subject verb. The court found the plaintiff was not grossly negligent per se. So basically, the courts find that subject verb. Another example is this: court finds that subject verb. If the court finds that the evidence is relevant, then it shall enter an order stating that the evidence may be admitted. So basically, these are the terms that we use in expressing establishment of fact. We have two more, which is also very, very often used. So we must know them also. But it's first of all, is the court held that subject verb, and an example for that: the court found, sorry, the court held that the defendant didn't commit any infringement. Again, this can be shortened. We can say that held, the defendant didn't commit any infringement. This is much the same meaning. Okay, then we have the appeals. When one of the parties are not satisfied or do not accept the judgment, then they can place their appeal. Let's see what we have to know about it in UK and US law. In lawsuits where one of the parties disagrees with the decision rendered by the court or jury, the party may appeal the case to the next court level. Generally, before appealing, the appellant must have requested a new trial from the trial court in his motions. describing errors in law or inaccurate factual findings. The trial judge may deny the motion, whereupon the party may proceed to the next level, where she may file the appeal. This notice of appeal is filed with the court and the opposing party within a specific deadline. If in the appellate process, the parties will file appellate briefs, so both parties will file their statements, setting forth the arguments concerning the error that took place in the trial. The appellee must then respond to the initial brief filed by the appellant with his or her answer to the particulars of the brief. Then the parties may also argue their case before the court in an oral argument, followed by the decisions to be rendered by the appellate court. Again, so this is another trial, and we will see what expressions or what expressions are used by US and UK lawyers in appeals. For example, the person brings or files or lodges or make represent to pursue appeal from the decision of the court or against the judgment or the court. For example, we can say that the person appealed to court from the judgment, the plaintiff appeals to the Court of Appeals from the final judgment. So this is a very nice English sentence, and we have here the sentence patterns. Person appealed to court from judgment, and this will help us to create our Uzbek sentences in very, very good legal English. Again, we have a sample sentence here. Susan has appealed the November decision of the Industrial Board. So the sentence patterns is person appeal the court decision. Okay, so basically this is the basic ideas, and then when we have to express our purpose, so there is a purpose always in appeals. So let's see what linguistic options we have. The company has appealed seeking to reverse the judgment on the grounds. So basically the company appealed and asks the court to reverse the judgment. And the sentence pattern here we have is person appealed seeking to. This is also a very nice sentence patterns, and if we use them, our sentences will be very good standard. For example, let's see the next sentence. The plaza has appealed asking the court to make a new and different declaration. Again, here we have the sentence patterns. Again, the third way of expressing purpose in appeals, the officer has appealed to this court requesting reinstatement to his former employment. So appealed to the court and requested the court to do something. So this is how we express purpose in appeals. So let's see what a court can do with the appeal. So the court can receive it, hear it, consider it, decide, a judge, serve notice of the appeal, and then when he considers it, the court can allow or grant the appeal, which means that the court will accept the appeal, or when it doesn't doesn't allows or doesn't grant the appeal, it means that it dismisses or denies or rejects the appeal. And then we will now see what expressions we have to express successful and unsuccessful appeals. Let's refer to successful appeals. So basically, as I told you here, the court can allow an appeal, and here we have a sample sentence for that. The court allowed the appeal and set aside the verdict and judgment at trial. So basically, the court can allow appeal, and then Also, the court can grant the appeal. And let's see another option. On appeal, subject verb. On appeal, the petitioner was accorded a new trial. So this is a success for the petitioner. And then the other very often used expression is held allowing appeal, subject verb. Held allowing the appeal, the plaintiff hadn't exhausted the remedies. So this is also very useful and widely used sentence pattern here. And then we have the unsuccessful appeals. A judge can dismiss an appeal. A judge may dismiss or otherwise determine an appeal and other proceedings. Or the appeal can be dismissed, or an appeal doesn't lie from the court decision. It means that there is no way to make an appeal against the court decision. Again, if we have the held allowing the appeal subject verb, then we have held dismissing the appeal, that subject verb. For example, the sentence held dismissing the appeals that the defense is pleaded by the appellant failed. Also, the court can reject the appeal. The Supreme Court reject the appeal brought by the defendant. Or we can say that on appeal, subject verb, on appeal, the appeal was dismissed. Okay, so basically appeals can be successful and unsuccessful, as I told, as we have just covered, and we have seen the linguistics options also. There are also a lot of other results of appeals. For example, the court can change the content of the ruling, or the court can maintain the ruling, which means that the ruling will stay as it is now. And then the court may suspend the ruling, which means, of course, that that the ruling is not valid for some time. And then the ruling can be terminated, which means that the ruling will have no force and effect. And then an appeal can result in the parties having to move to another court, and also an appeal can result in a new trial to be held. So there are a lot of other ways, other results that appeal can have, and we have just seen here. And also, parties during the trial may agree with one another. For example, in our case, the factory and the delivery company and the broken fence. In the trial, the parties may agree, okay, then you pay to me 2 million soms, Uzbek soms, and then we agree and that there will be no trial. And the legal and the expressions that the US and UK lawyers use is settle the case. For example, the company subsequently settled the case out of court, which is very important, settle the case out of court with a sum settlement, or the case is settled by agreement. Most civil cases are settled by mutual agreement between the parties, or the dispute can be settled. A dispute can be settled before a suit is filed, or the persons reach out of court agreement where subject verb. For example, the parties reached an out of court agreement where the plaintiffs agreed to dismiss the lawsuit. So basically, when the parties agree and there is no lawsuit, then the term settle the case out of court is very useful, or reach an out of court agreement, again very useful terms. Okay, we have just covered everything that I wished to tell you today about court action, lawsuits. There can be much more detail to it, because lawsuits are much more complex than this 1 hour presentation. Of course, in a 1 hour presentation, I cannot speak about everything and cannot mention about every expressions and every sentence patterns that we can use in lawsuits. It is a very complex case. We have just covered six very important topics in lawsuits. The last one was appeals and reaching the out of court agreement. But you can see here, this is a more detailed description of the civil procedure, and we have covered. You can see here, describing and providing notice of the claim. We have seen this one. We have seen responding to claims and admission and denial and defending your case. We have seen it. And then we have covered establishing fact by the court. And then we covered here the court decisions, and we covered the appeal process. And basically, a lawsuit is much more complex than these just 6 topics I have just covered here. And also, and 1 hour presentation is not enough to cover the entire lawsuit from beginning to end with all details. But this overview is much more detailed, and this can be useful. Again, this is in my book. I'm just telling it that if you want to be very good, very perfect in lawsuits, then it's a good idea to have this book and cover everything that is described here. So basically, as I mentioned in my presentation about company law, yes, you will have your law degree from the law university, Tashkent Law University, and then probably you will go to a law office, a law company, or you will go to a company, a legal department of a company, and you will have to deal with lawsuits, and you will have to deal with company issues. And if you have an English-speaking client, then you will have to know these sentence patterns. And if you use these sentence patterns that we have covered also in this presentation, then your legal English sentences will be excellent. So that's what I wanted to tell you about lawsuits. And if you have questions, I am more than happy to try to answer them.
Yeah. Dear Laszlo, thank you for brilliant presentation. I think our students find them very useful, especially we cover the civil law in our syllabus, and we also cover couple of these sentence patterns you said, but we don't cover all of them even during the lesson. It will be a super difficult job to cover all the things. Okay, one of my students is asking a question, and let me read the question and out of loud. Okay, the question is asking like this: What's about the situation with the consideration of petitions in a court according to the structure? How will you prescribe it, since the court can both grant the petition and reject it? And the question is asking about the consideration of petitions. What kind of language do we use in these situations?
Well, just some. So, for example, the court accepts. I'm writing some sentence patterns. The court accepts statement or allegation made by party 1, or the court considers the statement made by party 1 and finds that subject. This can be useful. The court considers the statement and accepts them and finds that something happens.
I believe
basically this is the part of fact finding process.
I believe the second sentence pattern is going to really work brilliantly in these situations. Okay, dear participants, if you have any questions, feel free. Still, we have a couple more minutes till the end of our event. If you have any questions, you can just drop down in a chat box, or you can raise your hands and ask right away. I believe no one is asking any questions. I think we can end up our event right here. And dear Laszlo, I would like to thank you one more time for joining us and spending your time, especially your 3 events was very useful for our students. Especially I found the first one very useful, and I believe our students has your email from the first event, and if they have any questions, they will be just writing to you to get the expert's opinion. And we came to the end of our this year events, and as you probably seen, we had overall 7 events, inviting 5 different keynote speakers from all over the world, basically from Europe. And this year it was very productive, I believe. Especially your part was super productive and useful for everyone. And we are really happy, and on behalf of Tashkent State University of Law and Foreign Languages Department, I would like to appreciate all your time and respect you as a keynote speaker. And if our students learn something from you, it will be useful for their future. And one more time, thank you, dear Laszlo, and we really appreciate your effort and your time. Thank you, dear participants, for joining us and spending your time.
Well, I'm also very glad I could be with you, and also I'm very glad that I could share my knowledge with you. And really, I enjoyed it every moment. And as I sent to you the text about company law, I will send this lawsuit presentation to you also. And I hope you will find it useful. And I will ask Sardor to forward these two presentations to you, so you can use it for your private study.
Thank you. I'll be glad. I'll be glad. Dear students, that's the end of our events. I hope we are going to organize these events one more time next year. And thank you, dear Laszlo. Take care. Bye-bye.
Bye-bye.